everyone. Welcome back to the OKT podcast. Thanks for tuning in to another episode where we deliver to you fresh insights and analysis on developments in Indigenous rights law in Canada. Today, we bring you an episode on the new Supreme Court case in Pekuakamiulnuatsh Takuhikan versus the Attorney General of Quebec, a new decision of the Supreme Court that has a lot to say about agreements between the Crown and First Nations. My name is Senwung Luk. I'm going to be your host with the most for this episode. I'm a partner here at OKT, and I do a lot of litigation on Section 35 rights. And I'm very happy to have with me three of my colleagues. So I'll ask them to introduce themselves. Tomáš.
My name's Tomáš, and as Senwung said, I'm an associate here at OKT. I'm originally from the Blood Reserve in southern Alberta, but I was raised up north in Whitehorse, Yukon.
And Eileen.
My name's Eileen Church Carson. I'm an associate here at OKT. I primarily work in litigation, and I was born and raised here in Toronto.
And Corey.
My name's Corey Shefman. I am a partner at OKT. And in addition to this podcast, you may have seen me on the Great Canadian Baking Show. I love to bake.
All right, so let's start with a public service. Because the name is in Innu language, I think a lot of our listeners would appreciate some practice in how to say the name of the case and the name of the First Nation correctly. So I'm going to invite Eileen, who has done some research on this very topic.
Great. So the community has a wonderful website that has a variety of terms with a native speaker pronouncing them, and I'll just play for all of us today the name of the band council, which is the Pekuakamiulnuatsh Takuhikan, which is the appellant or the respondent in the case. So here it goes.
Pekuakamiulnuatsh Takuhikan.
So should we practice that?
Should we all do it together?
Yeah, that's off.
All right, 1, 2, 3. Pekuakamiulnuatsh Takuhikan.
All right.
Pretty good.
All right, so let's get into it. Eileen, can you start us off by giving us a summary of what this case is about?
So the background facts to the case are that Canada, Quebec, and Pekuakamiulnuatsh First Nations Band Council signed agreements starting in the 90s to establish the funding necessary to create an Indigenous police force for the community. And those agreements were short-term, but they had renewal terms. So they were renewed many, many times up until the present. And there was a clause in each contract for that renewal. And under the agreements, Canada and Ontario would provide funding up to, Canada and Quebec. That's my Toronto bias right there showing. The two governments would provide funding up to a maximum amount that was provided for under the terms of the contract. And then the Band Council would run the police force and would take on any deficits if the Indigenous police force had operating costs that went above the maximum funding amount. And so this case really was about the years 2013 to 2017 when there was a pretty massive operation deficit, about $1.6 million. And even though the governments knew about that deficit and knew the importance of having an Indigenous police force for the community, they still didn't come to the negotiation table when the contracts were up for renewal to increase funding for the next contract. And so this case was about whether or not, by not coming to the negotiation table before renewing the agreements, the government of Canada and the government of Quebec had breached contract obligation or private law obligations, and then also whether they breached obligations specific to Aboriginal law. So the two issues that came up in the case were whether Quebec and Canada had breached private law duty to perform their agreement in good faith and a public law duty arising from the Aboriginal law principle of the honor of the Crown. And in the decision below the Supreme Court, the Quebec Court of Appeal said yes to both and ordered Canada and Quebec to pay the full deficit. Canada, after that decision, did so, and they didn't appeal. So it's just Quebec that was the appellant in the Supreme Court decision. And what ended up happening was the Supreme Court confirmed the decision of the Court of Appeal and ordered Quebec to pay its portion of the remaining deficit.
Okay, thank you, Eileen. This case is very clearly very important for Pekuakamiulnuatsh First Nation. Do you think it's also important for other First Nations in Canada?
Absolutely. This is something that's going to change the way that First Nations negotiate with various crowns, with any crown government. And it's going to change the way that crown governments negotiate with First Nations. And so when a First Nation, if you are part of First Nation leadership or representing a First Nation in negotiations with a crown government, you're going to need to be paying attention to some of the things that the court said in this case, and we're going to talk about those coming up. And it's going to change the way the contracts are drafted also. A lot of people often, sort of dismiss the preamble of a contract or, the purposes section, right? This is just introductory material. It's boilerplate. Well, it turns out it's not. Turns out it's actually really important. And that's what we're going to get into.
So definitely the most novel part of this case is the application of the honor of the crown to contractual interpretation. It is the first time the Supreme Court's given us a test and explained how the honor of the crown will inform contracts or the application of contracts. But I don't think that's the only takeaway or important thing for First Nations. As Eileen said before, the case turned on both the honor of the crown, but it also turned on good faith. And as we'll talk about later in the podcast, there's a two-part test for the application of the honor of the crown in contract law now. So not every contract that a First Nation enters into is going to trigger the application of the honor of the crown. But the court did confirm that every contract that is entered into will be subject to a duty of good faith.
One takeaway for me was specifically about the kinds of rights that were the subject of this contract, that the court, decided to create this test about when the duty of the honor of the crown applies to contracts. So here, Pekuakamiulnuatsh First Nation didn't have a modern treaty. They had an agreement in principle. And that agreement in principle talked about self-government of the police service, but there wasn't a recognized right. There wasn't a decision from the court saying that self-government right existed, but still that asserted credible right was enough to attract the honor of the crown. And I think, there's a lot of First Nations across the country that are in this interim phase between, rights assertion and the initiation of negotiations without having a modern treaty. And I think this case will be important for lending some weight to some of the existing interim agreements that exist between the Crown and Indigenous communities that have, really credible title claims, Aboriginal rights claims, and self-government claims that haven't, made it to the end of the treaty negotiation process.
Well, it sounds like there is a lot to talk about and a lot of interesting new developments that this case is signaling. So let's drill down specifically on a couple of things. I think the good faith idea and the honor of the crown idea are two of the big pieces that come from this case. So let's start with the idea of good faith. What that means, what that's about.
Good faith has been around for a fair bit longer now than the honor of the crown in the context of contract law. And it's something that attaches to every contract. And basically, if you're other party, you can't explore the contract. You can't act on the contract in a dishonest way. You can't take advantage of the other contracting party. It's quite broad, but there are some specific applications in this context. Here, the court said that the Crown, it can't insist on the operation of contractual terms if those terms were begotten by basically taking advantage of the vulnerability of the First Nation on the other side. It means that you have to consider the First Nation's perspective when you're the Crown and when you're deciding on acting upon a contract. And so there are a few specific things that it gets First Nations that I think are quite helpful.
So maybe it would help to give an example maybe of what was found to be bad faith in this case. How did the Crown behave? What did they do that the court eventually took issue with and found to be bad faith?
I think before we talk about what the bad faith was, it's important to
talk a little bit about what the court said the contractual undertaking was, because of course this is a private law obligation that arises from the agreement that you happen to have made. And so here the court said that there was an undertaking that was rooted in the purpose that's written in the contract, and then also some of the terms, like the fact that there was a renewal term and the fact that some of the terms of the contract talked about the future, that there was a contractual undertaking to maintain the force into the future. And so that undertaking required good faith performance.
The interesting thing is there was this term in the contract that said both Quebec and Canada were setting like maximum funding contributions, and that was still an issue with good faith. But where good faith became involved was in bad faith, and I think there are two. The one is Quebec's refusal to continue negotiating or consider whether to increase that maximum funding amount, despite knowing that Pekuakamiulnuatsh was in a quite difficult space. It was taking on these deficits year after year after year. And really the community only had two choices. It was either continue building up those deficits and operating a provincial police and operating its own Indigenous police force, or to accept that they couldn't fund the police force and then take the provincial police back. And so the court found that that was an example of bad faith because Quebec had known that this community was building up these deficits, and that the language used by the Court of Appeal and adopted by the Supreme Court was really like a knife to the First Nations throat while negotiating. And so that was the first example of bad faith.
Both of you talked about private law contracts. So I think just for our listeners, a private law contract is just a regular contract that First Nation could sign any day with Crown or other parties. Or two companies. So just to make sure I'm understanding it right, the point that the court was making was Quebec, while the Crowns and the First Nation agreed that there should be this police force, they signed an agreement talking about how to fund it. And then when it turned out that the funding that was provided was not going to be enough, the Crowns refused to talk about putting more money on the table and just said, good luck, you guys.
To give them a little bit of credit here, the Crowns had negotiated from the outset with the First Nation for there to be a maximum limit of funding, right? So in the original agreement, the First Nation had agreed with the Crown governments in a provision that said the funding will not exceed this amount. Now, like you said, it turns out that the need actually did exceed that amount. The budget deficit forced them to go over that amount. And so that's where I'm really interested in this idea about the purpose of the contract and how that the contractual purpose relates to this question of good faith and honor of the Crown. Because I think what we're going to end up seeing is situations where the Crown is setting these sorts of limits, saying we will not fund more than X amount. But in order to actually accomplish the goal of the contract, well, maybe we do need to think beyond that. And so when and how can the court just, essentially ignore an express agreement in a contract in order to give effect to the larger purpose of it? As I understand it, is to order a remedy that ignored the express provisions of the contract. The contract says you shall not exceed this amount of funding, but the court said in order to accomplish the purposes of the contract, you actually do need to exceed that amount of funding.
They read in a contractual term, right, an implied term, that there was a contractual undertaking to keep this thing going. And what that meant was you have to negotiate before you go into the next renewal of the contract.
It's interesting because the common critique of good faith is that you're implying these terms that aren't necessarily bound in the consideration of the contract or what the goal or intention of the contract was. Is you're layering on top another set of obligations the party themselves didn't contract to. But what I found interesting about the case is they explained good faith is not creating additional obligations on top of the Crown, but it's really about affirming the purpose of the contract. The purpose of the contract here was funding pushes them further towards that purpose.
What you're saying is that the court is hindsight. They say hindsight is 20/20, and it sounds like what you're saying is that the court is essentially acting as this opportunity to look back and say, well, that original promise you made wasn't able to accomplish the goal that you set out, so we, the court, will help you do that by layering on those extra provisions. That's interesting.
It's not that it's reading in its own consideration, or it's not reading its own bargain to these parties' contract. It's just it's right in the point of the contract.
This goes back to what some of you were saying earlier about the importance of how you write the purpose of the contract into things like the recital or the purpose section that I think a lot of lawyers might have been treating as boilerplate. It actually is really important when it comes to the court looking at these agreements and construing what the purpose of that agreement is. So I think that's a great discussion of the good faith ideas. Let's move on to the honor of the crown idea. It seems to me the court is saying that not every contract is going to attract duties flowing from the honor of the crown, but there's two sets of conditions that, if it's present in a contract, will attract the honor of the crown duties. And number one, that's a contract based on Indigenous difference. And number two, it's a contract based on a self-government right, even if that's asserted only. Those are some pretty technical terms. What does the court mean here?
The court spoke about it earlier this year in Dixon. This is the Van Kut-Gwitchen case, in which the court said that Section 25 of the Charter protected Indigenous difference, or the exercise of Indigenous laws that protected Indigenous difference. So there isn't a ton of case law interpreting what Indigenous difference means yet. The courts have relied on some secondary sources that talk about the fact that Indigenous people are culturally different, prior sovereignty, prior occupation. These are things that set apart Indigenous peoples from contracts with non-Indigenous peoples. So in this case, Indigenous difference was kind of founded on the fact that it was about an Indigenous police force that was going to police this community in a culturally aware manner, and that it was meant to remedy kind of the past grievances of Indigenous communities with police forces in the Crown. So, I mean, it's kind of a nebulous term, and it's hard to pin down, but it seems quite a broad definition, at least. I mean, if it's going to be vague, at least it's vague on the side of First Nations, in my opinion. So that's kind of the first criterion. And then the second one you mentioned, Sen, was a contract based on an asserted self-governance right. Again, I find this as somewhat, I'm curious about your guys' thoughts. I also find this as somewhat nebulous criteria. But luckily, the court analogized to the duty to consult jurisprudence.
Is that lucky?
I think, luckily, in that they adopted it just needs to be asserted, right? You don't need to make out the self-governance right, which is, I mean, self-governance is a pretty high bar to hit. The court hasn't given us the criteria for how to make out that right yet. So it's somewhat hard. How do you show you have a credible claim to self-governance when the court hasn't actually told us what will make out self-governance?
I'm going to push on that a bit, because every time a First Nation signs a contract, that's a decision of the collective. It's a decision of the self-governing body that's self-governing the First Nation. Isn't the decision to enter into any sort of contract an act of self-government in and of itself?
Well, I mean, depending on who you ask,
It may also be, and is certainly sometimes, an exercise of the powers of the Council of the Band pursuant to the Indian Act. We have lots of clients, and there are lots of Indigenous nations in Canada that draw very clear and visible lines between the conduct they take as Indigenous nations versus the conduct they take as Indian bands. One's a creation of the federal government, the colonial government, and one is inherent right to do the things that they've always been doing. We think about cases like Pamajuan, for example, where First Nation claimed a right to Section 35 protected right to self-government in the area of regulating gaming. And this is something that a lot of First Nations, claim a right to. And the courts over the years have said no several times to that being a self-government right. I think the problem is that when you get to this question of, when is an asserted right enough? When are you asserting it strongly enough? The tests that our clients are asked to meet are very vague, very nebulous, and often up to the whim of a court or a crown to say, yeah, okay, I see it, or not. And so I think what we're in for is a lot of back and forth, and a lot of need to be very careful and very intentional when drafting these contracts. I want to see in these contracts real highlights in the preamble sections about the Indigenous difference, about why this contract isn't just a commercial agreement between two companies, but is related to, if they're clearing roads, for example, it seems like a commercial contract, but maybe this is about the First Nations traditional practice of maintaining travel routes in their traditional territory. Let's get creative. The court calls for creativity in these remedies, well, let's get creative in the contract drafting too.
Thanks, Corey. Tomáš, you were taking us through the reasoning of how honor of the crown figured into the court's decision. Do you mind taking us to the end of that train of thought?
I mean, the most important thing I'd take away from the application of the honor of the crown is that the crown can never contract out of the honor of the crown, which is really important for First Nations to know here, is that I think there may be a concern on the part of the crown and crown lawyers that your objective words written into the contract may not hold water at the end of the day. I think that's a fair concern. There's a concern about ongoing contracts between, or negotiating new contracts between the Crown and First Nations.
So Tomáš, contracting out of the honor of the Crown, that's when the Crown lawyer puts a paper in front of a First Nation and tries to get the First Nation to say the honor of the Crown doesn't apply here, right? And the court is saying you can't do that.
Yeah, the court is saying the honor of the Crown always applies. And so that's important to know. It could be a challenge when negotiating these contracts because it somewhat limits the ability of the Crown to go back to the example. Quebec and Canada put in place these maximum funding amounts, these provisions, but it didn't matter because the honor of the Crown was present. And so it somewhat could undermine confidence, I suppose, in the ability of contracting parties to really stand firm on these provisions that they've negotiated to put into contracts.
Would Canada contract in the first place if they knew those maximum funding agreements didn't apply? Yeah. I mean, that's, I think, the problem that we're going to have looking forward. You know, if our Crown's going to be willing to take those leaps.
But doesn't the court say that if the Crowns had shown up at the negotiating table and talked in good faith about those maximum funding limits, that they might not have been offside, that it was more about the way that they comported themselves at these tables that the court eventually found to be what the court called sharp dealing and in breach of the duties arising from the honor of the Crown, right?
I think one of the messages here
is it's better to perform your honorable obligations than wind up in court having breached them, because there's a heavy hammer now that's available. And I think a lot of what you hear from the court is if you had negotiated, you wouldn't have necessarily had to pay for everything the First Nation needed to run this police force. There could have still been an operating deficit, but because you didn't act honorably, the remedy that was ordered was everything, right? So yes, there might be some difficulties in negotiating contracts, but hopefully this will improve negotiations once contracts are in place.
Is the message to the Crown: show up and talk like a regular human, as if you were listening and ready to hear what the needs are. Is that a fair summary of what the court is saying?
I mean, this gets a little bit into what the obligations are that flow from the honor of the Crown, but I think high level is definitely when you're negotiating, act with integrity, and also when you're performing the contract, even though it's written out, interpret it generously, be fair, don't take advantage of the power imbalance that might be there, all of those things.
Bringing it back to the duty to consult, like Tomáš was saying, you know, we've heard the duty to consult jurisprudence that it's not good enough for the Crown to just show up and listen, right? They can't have, the Federal Court of Appeal said in Tsleil-Waututh, mere note takers showing up to these meetings. And so I would think that a similar rule would apply here, that you know, maybe they didn't need to exceed the maximum funding amount. Maybe they didn't need to agree. But I would think that the Crown certainly would have needed to do more than just show up and talk. You know, we're getting into that same duty to consult area of there needed to be an attempt to understand, to see the Indigenous community's point of view. And I would argue, if I was representing the First Nation in this case, I would argue that if the Crown ended up continuing to refuse to exceed those maximums, that they might have needed to provide reasons. I mean, it really is transforming this private law contract into a public law, almost administrative process. But if, as the court says, the honor of the Crown is always there, then that's something that it's a safeguard that the Crown needs to be aware of.
Okay, so that kind of shades us into the next question I had for the group, which is, what's new here? How has this new case pushed us beyond where we thought the law was a week ago?
The obvious thing that Tomáš brought up earlier is that this is the first case that has applied duties arising from the honor of the Crown to contracts. And I think the obligations that actually flow from that are not entirely unexpected. The court looked at what the duties that have already been recognized are in treaty cases and really translated them over to the contract context. I think one thing was a bit unexpected and I think good was the court was really clear that this isn't an implied contractual obligation. It's a separate set of obligations that are overlaid on top of the contract. But the actual duties that we saw were very similar to what we saw in the treaty context. So no sharp dealing when you're negotiating, don't adopt a transient attitude, have an open mind with the goal of engaging in genuine negotiation, act honorably, form your agreement with integrity, avoid imbalance.
This is above and beyond like private law obligations, what you have in contract. And I think one of the issues in the jurisprudence lately is that we've been finding like more and more honor of the crown breaches and then wondering what the remedies for those breaches are. It seems harder and harder to make up fiduciary duties. So it's kind of, what do we get if we don't get fiduciary duties? And the court's been saying honor of the crown. And this is an example of that, right? That we're getting something beyond what you would get with your private law remedies. And I think that's really exciting to see what exactly the breach of the honor of the crown can get you in terms of like compensation.
Great segue to my next question, which is, well, what did Pekuakamiulnuatsh get out of this lawsuit?
Got reconciliatory justice, which is a new term that the court coined, which what they explained it as is in the private law context. So for example, with the contract breach of the duty of good faith, you have a remedy there. It was restitution, a remedy that's directed at putting the party that was hurt back in the place they would have been if they hadn't been hurt. So restitution would have been the amount of money that foreseeably the First Nation would have gotten at the negotiating table. So like I mentioned earlier, not 100%, but foreseeably where a negotiation would have landed.
That's a theory of damages that
It's consistent sort of across private law obligations, torts, contract law, etc.
Exactly. So it's corrective justice. It's correcting the legal wrong, putting the parties back where they would have been if something hadn't gone wrong. And this term reconciliatory justice indicates that something else is happening with a remedy for a breach of the duty arising from the honor of the crown. And I mean, I found the explanation both really positive in that it gives us something more, but also pretty loosey-goosey. It felt like, you know, there's a lot of flexibility. Courts should be creative. There's a lot of court discretion. And so I do worry a little bit that we're still in a place where we can end up with just bare declarations. The court was really clear, like shot both sides. It doubled down on that. The declarations can sometimes be what is required to put parties on the path to reconciliation. So I think we got further on, you know, where we can get in a really generous way from these remedies, but we also have, you know, the floor is still a declaration. But what the court said was that the remedy needs to serve reconciliation. So it should improve the relationship between the Indigenous community and the Crown and put them back on the path to reconciliation. And here it meant compensation above corrective justice. So all of the deficit was something that was meant to not just compensate for the wrong, but also put them towards something positive in the future was kind of the idea. So I think there's a lot of ambiguity in what this will mean for other cases, which I'm a little concerned about with, but I think it's generally good.
I mean, one of the exciting things
and frustrating things about working in this area is that the law is being made right in front of our eyes, but sometimes it's not being made the way that we would like it to be made. You hit the nail on the head when it comes to this discretion that's being left to lower courts. In some cases, that's going to be potentially really helpful. We could find ourselves with really creative remedies, and Justice Kazir refers to Justice Jamal's comments in Restool, which came out recently as well, about the imperative to look for creative solutions. I mean, I think the Supreme Court is sending a message to lower courts that they shouldn't feel constrained by the common law and equitable remedies that they're used to giving. The problem is the lower courts are common law and equity courts. That's what they do. And so the judges that we have in Canada, I think by and large, are very, very high caliber. But most of them will encounter a hard Aboriginal rights Section 35 case once or twice in their judicial career. These questions of reconciliatory justice are going to be, I don't think there's any question, these are going to be the subject of frequent litigation across the country. And what that ends up meaning is a lot of cost for Indigenous peoples who probably have better things to spend the money on. Is it a positive development? Sure, it's a positive development. Maybe it will unstick judges from this idea that all they can do is declarations, that's sort of the baseline. But there's going to be a lot of people who are nervous about taking that next step. There's going to be a lot of crowns who, I can tell you they're probably working away in the Crown's office right now to come up with contractual terms to limit reconciliatory damages. And we have the sui generis problem again. When I was in law school 12 years ago, there was sort of this collective giggle at the idea that, well, if it's Aboriginal law, it's sui generis, and so, you can make it up.
Well, in our efforts to push against the loosey-goosey in our common law system, I guess that's where new cases come into play. So I want to ask each of you to put on your imagination hats and think of one situation where these new ideas from this new Supreme Court case could apply. So who wants to go first?
I think I have an example. The honor of the Crown applying, right? Like the provision of education to First Nations people with First Nations teachers in the First Nations curriculum surely has to be Indigenous difference to my mind. And then the self-provision of education, I would also expect to fall under the umbrella of self-government. So I would think that First Nations school boards, First Nations education contracts between the Crown and First Nations about education would fall under this umbrella. If I imagine that it's like funding arrangements between the Crown and the First Nations school board for the payment of teachers, the payment of First Nations school board expenses, things like that, I think it would mean that the school boards couldn't just be left in limbo while waiting for this type of funding, that the Crown would have to come to the table when negotiating any sorts of like wages or the provision of funding to these boards.
I think I would even go beyond that.
Where those sorts of agreements seem to me that they would be at the heart of Indigenous self-government. Areas where, you want to indigenize the curriculum, it wouldn't just be about parity with non-Indigenous school boards, but it would be about the Crown having an obligation, having a reconciliatory justice obligation to ensure that in order to accomplish that goal of enhancing or establishing Indigenous self-government over education, that they're providing space and funds for Indigenous language training, traditional practice education, the sorts of things that don't necessarily have a place in settler school boards, but are central or integral to the identity of the nation who's offering these educational services.
That came to mind for me was not about the application of the honor of the Crown to contracts, but these reconciliatory justice remedies and the other places that we can kind of assume that they build on the existing honor of the Crown doctrine. So, for example, the duty to diligently implement a treaty, we've seen some case law on that recently, but we've gotten some declarations and other remedies. But in theory, that's an obligation arising from the honor of the Crown where this decision and its explanation of what the remedies available for that are would apply. So you could have, a treaty that's been breached historically that maybe the remedy is much broader, that it might be worth, pursuing that in a way that it wasn't before for a First Nation when it seemed like perhaps that litigation would just be about getting a declaration.
I'd build on that
and say that this maybe answers, or it provides one answer to the long-standing question we've had in Canadian Aboriginal law about what do you do when the duty to consult gets breached. The court has said that there can be damages for duty to consult breaches, but no one has ever given us an answer of what that looks like. What compensation, which used to be the only real applicable theory for damages, compensatory damages, what that looks like in the context of a breach of the duty to consult. But now we have reconciliatory justice. At paragraph 148, the court describes it as transcending the corrective justice at the heart of private law to, quote, make room for repairing and maintaining the special relationship with Indigenous peoples on whom European laws and customs were imposed, end quote. This could end up seeing a lot of activity around duty to consult breaches, especially with recent decisions around free entry mining in British Columbia and some cases that have been filed in Ontario and Quebec as well. So I think that would be very interesting to see where that goes.
Another example of contracts, child welfare contracts, I would imagine. Like it's now established like a self-governance right over child welfare. So I'd imagine any agreements between the Crown for the provision of child welfare services would also have the honor of the Crown attached to them.
All very interesting. Thank you. So we have time for one more question. So why don't we close off with this one? What should folks who are in First Nations leadership, who are managing their relationship with the Crown, what should they be thinking about in light of this decision?
I think the first thing I would say is that there's no such thing as a small contract anymore between Indigenous governments and Crown governments. Any contract signed between Indigenous governments and Crown governments needs to be considered carefully. Indigenous governments should have the same level of legal advice that Crown governments have. And you better believe that Crown governments have lawyers looking at every single one of their contracts. And the lawyers who are doing that work for Indigenous governments need to be scrutinizing the parts of contracts that haven't always been the focus of lawyers' attention. Everyone's very interested in the clauses dealing with breach and the clauses dealing with confidentiality and term limits and whatnot. But the preamble and the purpose, those are things which need close scrutiny, which need attention. And thinking about, when you're engaging in those negotiations, if you're in a leadership position within a First Nation, thinking about how you negotiate those agreements with Crown representatives to make sure that the Crown understands that what they're negotiating is an artifact of self-government. That even when it seems like it's a private contract that you're engaging in because this is a government, this is an Indigenous government that has inherent rights to govern itself and its territory, and not because it's just some other stakeholder or whatever. And so being intentional with your language, keeping great records is going to be very important to help build a case like this. Making sure that when you go to these meetings that you're being clear about why you're there.
Thank you, everyone, for your very deep thoughts on this exciting new development. It sounds like a case that we're going to be spending a lot of time over the next number of years talking about. So really glad to have your insights. And just a shout out to our audience members. Thank you so much for listening. I hope you've enjoyed this podcast and gotten some useful information out of it. Keep your ears peeled for future editions of the OKT podcast. We aim to bring you late-breaking information and clear analysis on all the new developments that are happening in the Aboriginal rights law space in Canada. Thank you very much.